All right, good afternoon, everybody. Thank you for joining us. I'm Neil Kalin. I am going to be hosting What's Up with Us today, the real property law section monthly webinar where we discuss new recent real estate cases that may be of interest to you. Today, I'm joined by Jose Mendoza, who's going to be co-hosting. Hello, Jose.
Hello, Neil. How everyone?
And we have a special guest, Ian McDonald, and we're going to get to Ian in just a little bit. Let's make sure everybody can hear you. Hello, Ian.
Hi, everybody. How was that?
All right. We hear you nice and clear. Good. So let's get us started today, because as usual, we've got some interesting things to talk about and interesting things to hear about from our guest, Ian. So you notice, let's see if I can get my screen to move here. Here we go. Here we go. So what's up with us? Normally it's myself and Michael Simpkin. Michael has better things to do than to join us today. So we are glad that Jose was able to take time out of his afternoon. We're going to be talking about 4 cases: Moses versus Roger McKeever, which is a property liability case; Barton Werfer versus Buckley, which is a bankruptcy case, but involves real estate activity. And we're very fortunate that Ian is going to be talking to us about that, because he represented the Barton Werfers basically all the way through their whole saga. And he's going to tell us a little bit about the saga, ending with a Supreme Court ruling. Our interview, we're going to move Ian up a little bit in the interview. We're going to talk to him in just a moment, because he has a court appearance he has to make. Then we're talking about Spencer versus City of Palos Verdes, and where the ruling is, guess what? It's not just individuals who can violate the Coastal Act. The city can violate the Coastal Act as well, and we'll find out more about that. And West Pueblo versus Stone Brewing, a really interesting case about force majeure that I think might raise some interesting questions for people. And Jose is going to be leading our discussion about that, as well as the Moses case. And as always, we're going to end up talking about the RPLS upcoming activities and education that hopefully you will be able to join in some of that and participate in some of that. So as we move on, we see, yes, here we go. Michael's not going to join us. Michael is being replaced by Jose. And they say, Michael, why couldn't Michael join us? And everybody has to make time for what matters. Of course, for me, what matters is our audience here on What's Up with Us. But for Michael, he thought his daughter's graduation from college was a little more important than doing a 1-hour monthly What's Up with Us. So I think we'll forgive Michael for being absent this month, and maybe we'll just razz him a little bit next month when he rejoins us on What's Up with Us. So Ian, we're here. We're so glad you're here. We want to make sure that you have time to prepare for your court appearance this afternoon.
Thank you.
So thank you, Ian. As you can see from the screen, he's with McDonald Fernandez. They specialize in turnaround, bankruptcy, insolvency. They have an office in San Francisco. They have another office, I think, where is it? Modesto? Is that your
Modesto,
office?
yeah, Central Valley.
Yeah. Okay. So they've got 2 offices. And Ian, first of all, I went to LinkedIn to find a picture of you. Kind of very impressive there, by the car, assuming I got the right picture from you. So tell us a little bit about yourself, your practice, how you came to be with McDonald Fernandez, and then we could talk a little bit about the Barton Werfer case, and really more about your experience with the case than the case itself. So tell us a little bit about yourself, Ian.
Well, you can appreciate the fact that I've been a lawyer for just over 50 years. I'm local. I went to University of San Francisco, although I have a Scottish name, which I see is now misspelled at the top, I-A-N. I spell it the Scottish way, which is I-A-I-N. And not a week goes by when some judge doesn't say, "Oh, counsel, I'm so sorry, we've misspelled your name here." That's just the way it's spelled. I went to USF and I got into bankruptcy work when I got a job with legal services, what was called San Francisco Neighborhood Legal Assistance Foundation, helping people in distress get rid of debt. And then I went to work for a very seasoned, well-known bankruptcy lawyer downtown San Francisco, Larry Goldberg. And the firm thereafter became Goldberg, Stinnett, and McDonald. But Bessers, Goldberg, and Stinnett have both gone on to their rewards. And I was practicing with Reno Fernandez, who was a very bright young guy who left to do appellate work because of some family issues he needed at the time, where he could be at home writing briefs than being out in court arguing. So the Bartenwerfer were debtors. They owned a house in the Diamond Heights area, San Francisco. They bought a house and they set about to remodel it, but they couldn't sell it because of the change in the economy in around 2008. So they fixed it up and moved in there. Ultimately, they were able to sell it to this fellow named Buckley, who turned out to be a pretty aggressive, I'm not going to tell you what they thought of him, but he was a pretty aggressive real estate guy. And he just sued the heck out of him for everything he could find in the house, a leak coming down the ceiling, a fire escape, everything. Took them to Superior Court, got a judgment for a few $100,000. They went into bankruptcy. He came roaring in, claiming fraud, that it was non-dischargeable. We lost our defense of that. He was able to prove, because there were findings in the Superior Court that were sufficient to support a verdict. That may be the first practice pointer we will get to, and that is that if you are finding yourself in Superior Court with a view to facing a potential bankruptcy, you want to do what you can to get those findings nailed down at that point, so you don't have to worry about litigating fraud later, which they had done pretty effectively. So they got the fraud judgment. Initially, Judge Blumenstiel, a bankruptcy judge, named the wife as co-judgment debtor, but we appealed that and we said, look, there's no evidence that she had anything to do with her husband's fraud. And so the bankruptcy appellate panel reversed and said, that's right, it should be a known or should have known standard. So they sent it back to Judge Blumenstiel. She conducted what came to be called a mini trial and found out.
Ian, I want to ask you a question about that. So when the bankruptcy appellate panel said it should have been a known or should have known standard, what did they base that on?
There's a line of authority. There's a line of authority that said that known or should have known was good enough to discharge the fraud, which actually turned out to be the error in the case. So they reversed it. She conducted what they were calling a mini trial. She found out she was clear. She didn't know anything about it. So she discharged it as to Kate, but not as to the husband. And the case then went on through the appellate track. And there we went back to the BAP. They affirmed. We went to the Ninth Circuit, by which time we were feeling very confident. Everyone was telling us, you've got this. Everybody was telling us that we had it in our back pockets and not to worry, but that did not turn out to be the case. We got reversed by the Ninth Circuit and a very skinny opinion that just cited 2 cases, not published. And then, of course, we looked at our clients and looked at each other and said, what do we do now? What are we going to do? I mean, I really wanted to see Kate get out of the case. And I had just coincidentally, a few years before, been admitted to practice the Supreme Court, only because I was in Washington for a convention. And the local bankruptcy judge arranged for first come, first serve, to be sworn in. So I went in and got sworn in. And so I was able to prepare with my partner a petition for certiorari and sign it myself and filed it and forgot about it. I thought, okay, that puts things on ice for a while because the bankruptcy judge had said, I will stay enforcement as long as you're appealing.
Okay.
In fact, the other side came in and they said, well, they lost in the Ninth Circuit, Your Honor. And I said, well, we're still appealing. And she said, okay, yeah, you are still appealing. So I'm going to keep the stay in effect. And then what happened is we started getting phone calls.
You're about to get to the substance of the Supreme Court, but I do have a factual question for you, because you said you were really trying to get Kate out of being responsible for the judgment.
Right.
So at that time, were they still a couple? Because you were just trying to get at least at the time that the property was originally sold, it sounds like they were a married couple. Were they still married at a later point in time?
That is the question everybody asks. Are they still together? And the answer is yes.
Okay.
They have a beautiful child, and they live together in the Sunset District, and that's the status quo right now.
Okay.
So I felt that it was a lost cause to try to get the husband out, but getting Kate, the spouse, out seemed pretty much to me to be something that had legs. But then when we got to the Ninth Circuit, that was not the case. And they relied on some old precedent and the language of the statute. And they rejected what was called the fresh start argument. And so they affirmed, they reversed the district court and held that the debt was non-dischargeable as to both spouses. So what happened after that was we had to decide whether we would go to the Supreme Court. And we knew that about 1 in 10,000 petitions is granted. But my partner is a very excellent brief writer. And he just did a really fine job. I could blow his horn. He filed a petition basically telling the Supreme Court why they should grant certiorari. And one thing he put in the brief that you don't usually see, he put in a section about how good Kate was, what a good person she was. She's really a clean person. She's not going to cause any embarrassment to the Supreme Court if you grant her the right to appeal. What happens next is I start getting emails and phone calls from lawyers around the country saying, hey, can we work with you on this case? Or even to the point of saying, can we do this appeal for you for free? And I said, wow, what's going on here? And then shortly thereafter, we got word that the Supreme Court had granted certiorari. So then I thought, wow, I guess I better take a look at who these people are that want to help us. And of course, I told the client, and the client said, look, if you can get a blue chip firm like Williams and Connolly of DC to handle it, we want to do that. So I was not going to say, no, I'm the man, let me do it. I didn't want to do it. Of course, I'm glad I didn't. So Williams and Connolly came in, volunteers. They had a team of lawyers, team of law students, team of law clerks. And they had somebody who had many years of experience. So they took the appeal. They did a terrific brief. We went to court very confident because everybody had told us, you've got this again, don't worry about it. Went to the hearing, and when I got up to sit down at my table, somebody had put this in my seat. Anybody recognize this?
White feather?
Well, they call it a pen.
Oh.
It's a quill pen.
Okay.
And when you appear in front of the Supreme Court, you're given this. I'm sorry, I put it in my pocket and it got kind of rumpled. I hope Justice Stevens doesn't see this. But anyway, that's the takeaway. That's the takeaway.
Okay.
So while waiting in the lawyer's waiting room outside the court, the gentleman came striding by wearing a morning suit, which, as you may know, is what they wear at weddings in England. I said, well, why is he wearing that? And I was explained that he is from the Solicitor General's office. And it's traditional, but that's how they dress. Solicitor General's office. There's another piece of useless information for you. We came out, we sat down, and of course I was feeling very cocky and confident, and Clarence Thomas just jumped on us right away. Right away he jumped on us. I can't remember his exact question. And then every single justice after him had a question that was hostile. That's the different thing about appearing in the Supreme Court. Usually if you appear in front of a 3-judge panel, you'll have one judge who takes the lead, the other two kind of ride on his coattails. But here, every single one of these justices has had his law clerk research it, and they all had something to ask. They all had some idea where they were going with it. And it was just that, the train had just left the station. I mean, it was pretty hopeless. And I was not, although my partner said, no, I don't think it's going to be 9-0. I said, I think it's going to be 9-0. And it was 9-0 against us. So, and the decision was kind of interesting. They had 3 basic grounds. They looked at, this old 18th, 19th century cases that said this kind of debt was non-dischargeable. They looked at some of their own precedent. The debtor had also made a fresh start argument. And I remember when I first started practicing back in the 70s, there was a vacation pay case, and the Supreme Court let the debtor keep his vacation pay so he can enjoy a fresh start. And then everybody is citing fresh start. Everything is fresh start, whether it had nothing to do with it or not. And here's the Supreme Court. We made that argument. Supreme Court rejected that too. So we kind of left with our tails between our legs. And believe it or not, the case still goes on because Buckley is still wanting to get paid. And the reason I didn't mention, the reason we were fighting so hard to get Kate out of the case was because she was the breadwinner. She worked for a Silicon Valley firm. She made over $200,000 a year. And she was, her earnings were, pretty vulnerable. And in California, as you know, if you're living on earnings, you can collect 25%. Absent making a showing of good cause, to keep more than that. No, I'm sorry, you cannot keep 25%. You can keep 75%. The creditor can take 25%, unless you can make an argument that they must leave more on the table. So they then went and got more of a special collection defense firm to represent them. And I have kind of graciously stepped back from representing the Martin orphans. And my only contact with them is when some invitation like this comes up and I'm asked to give my 2 cents worth. And unfortunately, when you lose in the highest court in the land, there's nowhere to go. There's really nowhere to go after this. I didn't really do, the innocent debtor spouse much of a service in taking it up on appeal and losing it. But as I say, we really felt we didn't have anywhere to go. I mean, I had to do that to try to get Kate off the hook. That sounds like kind of a meager apology, but that's the way it came out.
Well, if you lost in the 9th Circuit and you're trying to protect your client's interest, that's your foremost responsibility as your client's lawyer.
That's
Not
true.
necessarily to set precedent in the future, but to try and assist your own client and to get them out of that obligation. Ian, I have a question going back to the very beginning, and if you said it, I apologize. When the property was first bought, was it bought for them to live in, or was it bought for them as an investment to fix and to flip?
I think they bought it to flip.
They bought it to flip.
They bought it to fix it and to flip it. In fact, I think one of the newspapers called it a home flip gone awry. So yeah, they bought it to flip it. I mean, they were a young couple, they knew everything, and they figured they could buy this and flip it and make some money. And they just got caught at a bad time, and then they ended up selling to a bad person. Everything just went wrong.
And I have a personal experience with a relative of mine that sold a property to a very aggressive buyer that wound up pursuing them. And years later, the seller was forced really to enter into a settlement agreement because it was becoming unsustainable to maintain the fees involved while being pursued by somebody who was so aggressive and so well funded. And
yeah, that's the story. Yeah, that is the story. And a lot of people see people flipping houses and making money, and they think, oh, this is easy. I'll just go and do that. Buy that house down the street. Sometimes it blows up.
Sometimes it does. Well, Ian, I know you only have a couple of minutes left. We do have some attendees today.
Sure.
Because we're so fortunate to have you with us. If anyone wants to ask you a question, put it in either the chat tab or the Q&A tab. We'll look at those just for a minute or so, and then we'll let Ian get ready to go to court.
While the questions may be popping up, a quick question to you, Ian. I'm a car guy, and I see that you're standing behind what appears to be a very great looking car. What is that? I just didn't recognize the brand.
Oh, you know what it is? Everywhere you see Rover, Range Rover, Land Rovers everywhere. That is the original Rover. It's a Rover 4-door sedan. It's fashioned after a Rolls Royce. They call it the poor man's Rolls Royce. It's a 1958 Rover, and it's an English car. And it still runs. Everybody asks me what it is. I bought it with my dad back in when I was in law school in 1970. Yeah, 1970s when I bought it.
And so you take it to Cars and Coffee?
Sure, yeah, take it everywhere.
Nice. Well, enjoy in great health.
Yeah, thank you. Anybody wants a ride, let me know. I'll come by and pick you up.
I may take you up on that offer.
Sure.
Yeah. Sure way. When I saw that picture, I knew that Jose would have something to ask about it.
Really? Okay.
So I'm so glad he's co-hosting today. I don't see any questions, and we don't want to hold you up any longer than we need to, Ian. So thank you. I apologize. When I got the right spelling of your name, I thought I went through and caught all of my errors in the presentation. So I apologize for that big gold block leaving out the I, but it is
That's no
correct in your contact information.
Well, the other thing that screws people up is the small D in the McDonald. And you can buy these at the gift shop. I think they're only $5 if you want to get one and put it on your desk. In fact, one of the lawyers, I think she's a little bit carried away, but if you look up feather in the Google it, you'll see a picture of one of our lawyers. And she has a bowl with about 45 feathers.
Oh.
To let you know how many times she's been to the Supreme Court. So there you go.
Very impressive, as are you. So thank you
you
for joining us today. We really appreciate it.
You're very welcome. Enjoyed it. Good luck, everybody.
Thanks, Ian.
All right. Thank you. All right, so let's move on to one of our other cases here. We got Moses versus Roger McKeever. And hey, Jose, why don't you take us through this one?
Sure. So this is pretty much a garden variety, in my eyes, a garden variety premises liability trip and fall, slip and fall case. In 2018, the plaintiff, who was a guest, she attended a gathering at a condominium complex. It was hosted by the tenant of one of the units at the condo, defendant Roger McKeever, last name. And 2 years later, the plaintiff, the guest, filed a lawsuit claiming that when she left the condominium complex and in the common areas, she tripped and fell at the entryway steps to the condo. The guest alleged that the tenant was aware of, or should have been aware of, the dangerous condition, including poor lighting, lack of handrails, step heights not code compliant, but still allowed it to exist. And the tenant, on the other hand, filed a motion for summary judgment in the trial court level. While the trial court decided for the tenant and granted the MSJ, the trial court held that the tenant had no control over the entryway steps or the outside lighting and had no duty to maintain or repair that area. The guest appealed, arguing that there were material facts that precluded an award of a summary judgment. Specifically, the guest argued in appeal that the tenant advised the landlord to repair the outside lighting prior to the event, in addition to other invitees informing the tenant of the poor lighting in the common areas during the night of the event, but the tenant failed to notify the guest. So when it came up to the appellate court looked at it and said, well, we're going to uphold the ruling on the motion for summary judgment, opining that every person has a duty to exercise in the management of his or her property or person reasonable care for the safety of others. This duty is not limited to one who holds title over the land, but also by the person in possession of the land. However, a defendant cannot be held liable for the defective or dangerous condition of the property which it does not own, possess, or control. If the tenant did exercise control over a common area, then he or she may become liable to invitees. So here, I mean, to me, it seems like a pretty straightforward case. If the tenant neither helped with the design or construction of the staircase, did not maintain it, did not control it, they had no obligation to the guests. Whereas if the guest tripped and fell inside the unit in which the tenant has complete control, possession, and maintenance obligations, the ruling would be different. But here it's, like I said, to me, it's a pretty straightforward, slip and fall case in the common areas. What's surprising, though, is I don't know, I didn't see from the court records whether or not the guest filed a lawsuit against the homeowners association or the owner, the landlord themselves, who may have had control over the common areas. Hopefully they did, because they may have some culpability there, but definitely not the tenant in this situation.
So Jose, when I was looking at this case, I was thinking of two cases that were discussed in the previous What's Up With Us presentation. And one case involved the builder developer of was having a construction project. I believe it was in somewhere outside of San Francisco, and they were improving two separate units, and in between them was a common walkway, so the neighbors could get from one part of the city to the other part. And one of the work person was assaulted, and the middle area was not owned by the builder developer. It was just working on these two separate projects that happened to be adjoining the walk area. and there was the potential of liability there depending on the facts. And the court said, it could be that the developer was deemed to have control over that separate unit. So like it says here in the case, it's not just ownership, but it's also control could be a deciding factor. And there was another case that we talked about, I think this one was maybe a year ago, where a guest coming to a party in a condominium complex was injured crossing the street from where they parked to get to the complex. And I believe they sued, I think it was the owner as opposed to the association, saying, that's dangerous. The only way to get you, because there's not adequate parking in the complex itself, the only way a guest can get to somebody's unit is by parking across the street and then crossing a busy street that does not have a light. And I believe there was no liability in that case. Again, it was not a common area. It was not owned. The association had no control over the public street. So it just, makes cases like this come up. There's issues that get involved, and you got to look carefully and decide what are the three. Is there management of the property? Is it owned, and is it controlled? And I think those are going to be factors no matter what the premises liability issue that comes up.
Correct. I mean, arguably, if the tenant thought that there was not enough lights and the tenant went and put in some, temporary lighting, and she tripped and fell nonetheless, the tenant may be exposing himself or herself to liability in that instance, because then, an argument could be made that now that by installing even temporary lighting, she now has took at least some portion of control over that common area. So in this instance, since she didn't put any temporary lighting or anything else to have control, there was no liability.
And so in the situation you just described, it sounds like if you tried to do a good deed, you could be punished for it. And so it's kind of sending a mixed message out, right, to the public at large. If you do something that could be helpful, then you could be exerting control, and you could find yourself in a liability situation.
Well, we get that all the, I get that all the time when I'm, helping, when I'm defending realtors. When realtors, with the service industry, when realtors try to go above and beyond and then try to obtain permits for a building, and then they found out that they're wrong permits or incomplete permits, you're opening up yourself to liability, because as you know, the law says a realtor does not have that obligation to look beyond the property and pull permits, Civil Code 2079.3. So again, that's a case where no good deed goes unpunished.
Hey, Jose, if you don't mind, I'm going to make one comment, and I'm going to give you 1 minute to say who you are, because I welcomed you as a co-host, but we don't know who you are. The story, the example you just mentioned, remind me of something that I heard when I got started in real estate almost 30 years ago. And it was a situation where a real estate licensee was trying to sell a person's home, a wealthy person, an estate, and they were going out of town, and the real estate licensee agreed to take care of the person's horse while they were out of town, saying, well, I want to keep this client happy. And lo and behold, what happened? The horse died while the client was out of town. And of course, that is way above what one is permitted to do with a real estate license. And I believe the real estate firm wrote a really big check in that particular case. So with that background, why don't you tell us what you do, Jose? And after you do that, we'll go on with our other cases.
Sure. So I am currently in-house counsel at Coldwell Banker. So I represent, Coldwell Banker, the corporate-owned entity in Southern California, and its agents from, lawsuits and claims involving the real property transactions. So, and before that, I worked at, private firms, dealing with the same issues, real estate transactions, deposits, construction defects, failure to disclose, so I'm well versed in real property cases now.
And Jose, do you, at your current in-house position, do you litigate, do you mediate, or do you just supervise others who are engaged in that activity on behalf of your client, Coldwell Banker?
So my official title is in-house litigation counsel. So I do litigate, and most of our cases are claims, but we do have numerous, active litigation files in which I handle. So, I still do a lot of trial court work.
Okay, well, great. We're so glad to have you with us. Let's move on to our next case. And the next case is the Bartenwerfer case. So no need for me to repeat everything that we talked about. And what I found interesting was that when Ian was talking about this case, and everyone he talked to said, you're going to win this case. And everything is on your side. This is as close as you can get, right, to having a sure thing. And when I was listening to Ian, I was reminded of something that one of my colleagues at CAR, the California Association of Realtors, used to tell me. He was in private practice before he went in-house at CAR, and he would constantly mention this, that a 100% sure thing is only 50% once you get to court. And apparently some of that rings true when you get to the United States Supreme Court as well.
Well, I find the ruling of the Supreme Court, I think I would agree with the Supreme Court ruling, because, to allow the wife to keep the money from the fraud, she benefited from the fraud, from the husband's fraud, right? Arguably, they received more money. So she shouldn't be able to hide behind it and keep the ill-gotten gains. At least that's my 2 cents.
I was convinced by the Supreme Court's reasoning as well. The one thing that I found a little bit maybe odd was they kept referring to the wife as a partner, as if this was a business relationship. And that's why I asked Ian, did they originally buy this property to live in or as an investment? And he said, no, this is originally purchased as an investment. I guess I ordinarily would not think of husband and wife as partners per se. I think of that as more of a business term. But maybe because that was the reason that they bought the property in the first place, that the Supreme Court use of that language makes more sense than I otherwise would have thought of. But otherwise I thought that the reasoning did make sense. The reasoning was sound. And as Ian said, it was a 9-0 decision. So the court, didn't even have a problem with this at all. So, all right. Very good. So let's move on. We got some other cases to discuss. Next one is the Spencer versus City of Palos Verdes case. And I just briefly mentioned it. What happened here? The case really factually goes back to the late 1980s, right? So we're talking, 20, 40 some years ago, 40 years ago. And local surfers, not one, began building this structure that became known as the Rock Fort. It was near an access point to this beach in Palos Verdes. And the structure had multiple purposes. It allowed the surfers to look out and view the surf. They used it as a patio area for eating and frolicking and partying, I suppose. And another purpose was to block access to outsiders who would come to the one entrance to this beach and see this big, rock structure and think, oh, I guess that there's no access here. The Coastal Commission got involved at some point, and the city wound up deconstructing the structure in 2016. But the locals, notice they're known as the Bay Boys, they rebuilt it. They rebuilt the structure, and then the plaintiffs allege in this case that these Bay Boys were really bad boys, and they would harass outsiders who were using or attempting to use the surf spot. They would vandalize their cars. They would throw rocks at them. They would insult them. They engage in a whole bunch of activity, again, that is presumed to be true for the purpose of the motion in this case. So the plaintiffs assert that the city violated the Coastal Act because they allowed the bad Bay Boys, A, to rebuild this structure, and B, to harass outsiders. And they said that's interference with the Coastal Act because it's limiting use of the coast. The city filed a motion for summary judgment. What happened? The trial court granted the city's motion for summary judgment. It's saying just because they allowed this fort to be rebuilt, okay, that's not an actionable allegation, and that the harassment itself, well, may be objectionable conduct. It's not conduct that is reached by the Coastal Act. The case was appealed. The appellate court says, well, one purpose of the act is what? Is to maximize public access, and the activity that's being alleged limits access to the coast. And what is covered by the act? And the court said, well, any kind of development under the act is covered under the act, but development is very broad-based as interpreted by the courts over the years. And they said it applies to one who acts passively or one who acts actively. And they gave an example. If a property owner allowed dumping to take place on the land, while that may have been passive activity of allowing the dumping, that would be actionable under the Coastal Act. Building structures, allowing structures to remain. There's a very famous case where there was an access point where there was a guardhouse leading down to a beach. Court said, that is actionable under the Coastal Act. And so here the court said, well, guess what? Intimidation can be covered under the Coastal Act, and the city, not just those bad Bay Boys, but the city itself, if they were engaged in some kind of conspiracy to allow this activity to go on, if they were aware of it, and there's allegations in the case that the city was aware of it and was favoring the local residents. So there, of course, this case is going to have to go back. Those allegations are going to have to be proven, but if they are proven, the city could have liability for violation of the Coastal Act, just like a property owner could. Jose?
Yeah, this is kind of interesting because I ride my bike a lot, and I've ridden to the Hollywood sign, probably half a dozen times. And I don't know if you've ever been to the Hollywood sign recently, but it makes it very difficult for the public, the residents in the area, and maybe because of the city allows them or looks the other way, the homeowners, the residents in that area make it difficult for people to access the Hollywood sign, because there is at least one area where there's a gate, there's a locked gate that doesn't allow any cars to go further up. There are residents who put up no parking signs or cones in their area, which aren't, city approved. So to me, this kind of reminded me of that, is like homeowners taking it under their own hands to limit the use of the public to access the trails heading up to the Hollywood sign.
And that's a really good, interesting comparison that you're making, Jose. Now, of course, the Hollywood sign is farther inland than the coast, and even though the Coastal Commission's jurisdiction extends beyond the mere water line and it goes in, I'm not sure exactly how far it goes in, it does not reach the Hollywood sign. But Jose, do you know, is the Hollywood sign itself on public property?
I don't know for sure, but I think it is but I don't know.
Okay.
I don't know. But I want to think it is because they do, you are allowed. It's designated hiking trails. People do
Right.
hike there all the time. I see it. And people bike there and people ride horses up there. So I don't know. If it was private, I'm sure they would have, gated it off entirely. And it does,
Right.
there are trails that connects you to the Griffith Park Observatory.
That's exactly right. That I have not hiked down to the sign itself, but there are trails that direct you to the Hollywood sign from the Griffith Park in the observatory area. So, okay, so here's just our lesson for Spencer versus City of Palos Verdes, which is that violations of the Coastal Act can extend beyond, right, individual property owners. Most times you hear about Coastal Act violations, it's usually an individual that's trying to block access because they want to preserve their own private beach. We've heard about cases in the last 2 years where a city has said, or an HOA has said, you cannot have short-term rentals, and that's been deemed to be a violation of the Coastal Act because it is restricting access. So we do know that there's some application beyond individual private owners, and Spencer simply just reiterates that. And at some point in time, we'll see if the facts prove out those allegations. All right, Jose, I think we got one more case, and it's your case to take us through.
Okay, great. So, these are some of the handful of cases that arise after the pandemic, right? We all know that there have been some closures limiting, dining at bars and restaurants. So this is one of those types of cases, and the implementation or the interpretation of force majeure clauses and leases. So here, this is a straightforward landlord suing the tenant. In this case, Stone Brewing is the defendant tenant. The landlord is West Pueblo for non-payment of rents during the pandemic. It was a 6-month period, or 6 months, that the tenant did not pay the landlord. And the tenant claimed that it was excused from paying rent due to the force majeure provision in the lease. And I think it's important to read that clause first before we actually do a deeper dive into the facts. So the specific provision of the lease says force majeure. If either party is delayed, interrupted, or prevented from performing any of its obligations under this lease, and such delay, interruption, or prevention is due to fire, act of God, governmental act, or failure to act, then the time for performance of the affected obligations of the party shall be extended for a period equivalent to the period of such delay, interruption, or prevention. So here we have the tenant is a brewing company and a retail corporation that owns multiple restaurants, and in this location, at least this location in Napa, which is owned by West Pueblo, the landlord. And so again, for 6 months, for a total of 6 months, the tenant failed to pay the landlord, claiming the governmental closures prohibited it from operating efficiently, and elected to trigger the force majeure clause to excuse it to pay rent to the landlord. The landlord filed an unlawful detainer action, and both parties filed competing motions for summary judgments. The trial court ruled in favor of the landlord, taking a strict interpretation of the force majeure language, opining that tenant's obligation to pay rent is only excused if the pandemic delayed, interrupted, or prevented the tenant from paying the rent. It did not apply here because the tenant had always had the ability to make the rental payments and simply made a financial decision not to pay the rent. The tenant, obviously distraught by that decision, appealed. And the appellate court ruled and affirmed the trial court's decision. Again, claiming that the strict interpretation of the force majeure provision says only if the pandemic interfered with the right to pay the rent would they be excused from performing, since they had the financial means to pay the rent, notwithstanding the intermittent loss of income or profitability. They're still on the hook to pay the rent. So that's how the appellate decision came down. In a similar case back in March of 2023, and another What's Up segment, they discussed, Neil and Michael Simkin discussed the SVAP3 versus fitness case. In that case, it was fairly similar. It was a fitness gym. That was operating and had to close its doors due to the governmental closures, and the gym elected to not pay rent to the landlord because it wasn't receiving any income. In that court, in the SVAP court, the appellate court affirmed the ruling that there was no evidence that the pandemic and resulting government orders hindered the fitness center's ability to pay rent. Nothing about the pandemic or resulting closure orders made the fitness center's performance of its obligation to the landlord impossible. Governmental acts that merely make performance unprofitable or more difficult or expensive do not suffice to excuse a contractual obligation. And that's what the appellate court used to rule in favor of the landlord here against the tenant, Stone Brewing, claiming you still had the financial wherewithal to pay the rent, and you were not excused from paying the rent in this case. I
Jose,
guess-
so I'm looking at this case and I'm thinking back to the SVAP case. And it seems like these force majeure cases really don't help, well-to-do, big corporate tenants, right? The ones you would think would have a bevy of lawyers, helping to draft these force majeure clauses for them. But if you're some large corporation and you have, independent assets that are not dependent upon that location, then the payment of rent issue, you're not going to be excused simply because of a force majeure clause. And I wonder if some entities are going to look at this, moving forward and say, well, maybe we'll just create a whole bunch of separate, LLCs for, for each location or something. I don't know, commercial leasing is not my specialty at all. But I was just thinking, maybe some entities will, going forward, kind of change their structure if it is important enough to them to avoid payment as a result of a force majeure clause.
Yeah, I hear you. There was, in the appellate decision in this case, though, what was telling was there was a 1 or 2 sentence discussion about the written discovery in this case, where the tenant admitted that it did generate an overall profit in January and February of 2021. So in 2 of the 6 months in which it withheld rent to the landlord, it actually generated a profit. So, I think obviously that, the appellate court looked at that and said, come on, you can't blow hot and cold. You can't say I
Yes.
suffered all this injury because of the pandemic, but at the same time made a profit.
Yeah, you're right. You can't argue it both ways, right?
Yeah.
All right, so a good case and one that's, you know, obviously very timely, given what happened over the last few years. Jose, we have just a few minutes left. Let me go through our RPLS activities. Yeah, you see, well, there was a webinar today, but it was from 12 to 1. So if you are interested in information about LIBOR, well, you're too late to catch it live, but you can catch it in the RPLS library. In August, there's a webinar addressing contractor estate license law. Got good ideas for webinars. There's the contact person, Marty Triano. He's done an absolutely tremendous job for real property section this year in making sure that we have webinars, I think, every single month since Marty's been in charge. So it's really been great, but always looking for good ideas. And maybe you want to, you know, get your name out there. And so you want to put on a webinar, contact Marty at trianoburn.com. Marty, I'm hoping that's your still your current address, because I know you're doing dispute resolution as well. But that's the address I have for you. Hopefully that's still a good address. Once again, we have a monthly e-newsletter. You want to discuss a case, short, you know, a page, maybe 2 pages discussion about a recent case that you've had or that you've read about. Great. You can contact Kyle Yagi, Kyle at hickmanrobinsonlaw.com. And if you want to write a law review type, you know, 20, 30 page article with, you know, dozens and dozens of citations, great. You know, put something in the Real Property Law Journal, and you can contact our editor-in-chief, brian.payne@arcadis.com. Hey, guess what? In 2 months, we're coming back. We're doing things live again. Hot August nights. It was a great party that was had a few years ago. They're bringing it back. It's at the Loma Club for those of you who are in San Diego, August 16th at 5:30. Stay cool. Show up at the Hot August nights at the Loma Club on August 16th. And just you know, quick reminder, the CLA annual meeting and gala is going to happen once again. It was in San Diego last year, great location, and it's back in San Diego this year, September 21 through 23rd. Lots of educational opportunities, and the gala is just a really nice, fun party. And if you like to get dressed up, it's I think it's black tie optional, so everybody's dressed up really nicely and fancy, and it's kind of nice. And you can see, again, you can get involved with their practice area committees. Our newest committee is the ADR committee for real estate. And I believe Marty Triano is actually in charge of that practice area committee as well. So look at these lots of opportunities for you to get involved with the real property law section. We'll be back next month, July 19th at 1 p.m. I already have a good list of cases for us to discuss in July, and we're a month away, so we'll see what else comes up in the next month. And I think Michael's going to be back. I don't think he could use his daughter's graduation as an excuse to miss July or June and July. So we'll see. Hey, Jose, why don't you end us up for the day? You're our guest. We're so glad to have you and to, you know, give your opinion on these cases we talked about. So why don't you end us up for the day?
Great, thank you all. Thanks for inviting me here today. Obviously, my pleasure anytime. And everyone, hopefully we'll see you again. The next What's Up with us is Wednesday, July 19th at 1 p.m. Until then, enjoy your days. Take care.
Thank you, everybody. Bye now. Have a good day.